Dear students, today we discuss Scandinavian Realism. The name Scandinavian Realism is generally applied to the writings of the Swedish philosopher Axel Hägerström and his disciples Anders Wilhelm Lundstedt, Karl Olivecrona and the Danish jurist Olivecrona. They were the chief exponents of the Scandinavian realist movement. Like American realists, they were concerned to explain the law as it is. But unlike the American realists, the Scandinavian realists did not concentrate on the working of the courts. Scandinavian realists insisted on disassociating all legal phenomena from metaphysics. As C.K. Ellen pointed out, if American realism is rule skeptic, Scandinavian realism may be described as metaphysical skeptical. A deep mistrust of metaphysical concepts, which was exhibited by both the legal positivists and American realists, reached its apogee with the writings of the Scandinavian realists. In the words of Olivecrona, all metaphysics are a chimera and there is no cognition other than empirical. The Scandinavian realism, which is founded on the teachings of Hägerström and to whom all other contemporary writers acknowledge their indebtedness, has played a vital but important part in the total rejection of natural law philosophy. The Scandinavian realists deny that the rules of legal conduct can be compellingly deduced from immutable and inalienable principles of justice. It is essentially a philosophical critique of the metaphysical foundations of law. Essential features of Scandinavian realism. The essential features of Scandinavian realism are as follows. Metaphysical speculation is to be rejected. Reality may be discovered and analyzed only through an investigation of the fundamental facts of the legal system. Jurisprudence must be a natural science based on empiricism. Assertions which are incapable of proof are nonsense. Hence, jurisprudential propositions which cannot be verified are unacceptable. Our morality is created by law, and our law does not emerge from our morality. Natural law is an illusion, and the jurisprudential arguments derived from it are unacceptable. Law is determined by social welfare, which includes the minimum requirements of material life, security of person and property, and freedom of action. Values such as goodness and badness are no more than the embodiment of reactions expressing approval of a stimulus. Law can be understood in terms of sets of psychological responses to groups of stimuli. Axel Hägerström, a Swedish philosopher, is the founder of the Scandinavian realist movement. He believed that empirical analysis, which involves the acceptance of sense data, would provide answers to questions concerning the origin, nature, and functions of the law. He wanted to establish a real legal science which could be applied to the reorganization of society in just the same way as the natural sciences had been used to transform the natural environment. To do this, legal science had to be emancipated from mythology, theology, and metaphysics. The important contribution to legal science which Hägerström made has been to probe beyond the rejection of transcendental justice into the validity of the entire apparatus of rights, duties, sovereignty, commands, and many other basic legal concepts which have formed the mainstay of analytical jurisprudence in the work of Austin and his Anglo-American successors, as well as continental analytical positivism. Although analytical positivists discarded concept of natural law or concept of justice, they substituted for such absolute imperatives the sovereignty of the modern state with an unconditional obedience to its commands, which in turn, by virtue of its omnipotence, confers rights and imposes duties on the subjects. But in all this, Hägerström and his successors found nothing except that a superstitious introduction of ideas taken from natural law. One of the most important critical contributions of Scandinavian realism is a criticism of a collective or general will or a will of the state as a mystical concept which aims at to legalize the omnipotence of those in command of the machinery of the state in a manner akin to that of natural law. Hägerström contended that rights, duties, obligations are in themselves meaningless concepts. He subjected the basic concepts of law to a critical analysis, especially the concept of right. The traditional view of a right has been that of a non-physical power enabling a person to have or do something lawfully. Hugo Grotius described a right as a moral power. According to Hägerström, such a conceptualization carried no meaning because it has no counterpart in the physical world. He pointed out that a right of ownership had no empirical significance unless and until it had been infringed and become the subject matter of a judicial proceeding. Even in that event, the litigant's claim to ownership was unreal and speculative until he had proved his title. In Hägerström's opinion, the term rights has meaning only when associated clearly with remedies and legal enforcement procedures. Hägerström also investigated the historical and psychological basis of the idea of right. He sought to trace the notion of right historically to the legal magic practiced by ancient systems of law and psychologically to the emotional strength of the feeling of a person who believes that he has a good and valid claim. According to Hägerström, the term justice represents in reality no more than a personal, highly subjective evaluation of some states of affairs of which we generally approve. He denied the existence of such things as goodness and badness and remarked that they represent simply emotional attitudes of approval or disapproval, respectively, towards certain facts and situations. He said that all questions of justice, aims and purposes of law are matters of personal evaluation, not susceptible to any scientific process of examination. His refusal to regard legal concepts as nothing more than fantasies of the mind is at the heart of the philosophies of his disciples Alf Ross, Karl Olivecrona and Lundstedt. Lundstedt followed the path of Hägerström in rejecting the pretensions of metaphysical interpretations of the law. According to him, nothing exists which cannot be proved as a fact. Judicial concepts such as rights, justice are illusory, and there is no scientific method of evaluating their basis. He says, feelings of justice do not direct law. On the contrary, they are directed by law. Law is not founded on justice, but on social needs and pressures. Law in any society is determined by social welfare, which is the guiding motive for our legal activities. Lundstedt says, law should be interpreted as simply the facts of social existence. All else is illusion. Judges should think in terms of social aims, not rights. He opposed the method of justice and insisted the method of social welfare. He said that the method of social welfare was free from all ethical evaluation, since the notion of social welfare referred merely to arrangements considered useful by men in a certain society at a certain time. Socially useful is that which is actually evaluated as a social interest. In his denunciation of the concepts of rights and duties and the rejection of transcendental ideas of justice, Lundstedt is in complete accord with other Scandinavian realists. While rejecting the method of justice, he points out that law is nothing but the very life of mankind in organized groups and the conditions which make possible peaceful coexistence of masses of individuals and social groups and the cooperation for other ends than mere existence and propagation. And at any particular time and in any particular society, law is determined by social welfare. The method of social welfare, which he propounds as a guiding motive for legal activities, means, in the first place, the encouragement in the best possible way of that, according to what everybody standing above certain minimum degree of culture is able to understand, which people in general actually strive to attain. This includes such familiar values as the minimum requirements of material life, security of life, limb and property, the greatest possible freedom of action and movement, along with limitation of the amount of work a person may be required to do within a specified period of time, possibilities of education, etc. In brief, all conceivable material comfort as well as the protection of spiritual interests. Olivecrona, who was illuminated the ideas of Hägerström, completely refrains from defining the expression law. And this is evident from his statement, I do not regard it necessary to formulate a definition of law. A description and an analysis of facts is all that will be attempted. If one wishes to explore the nature of law, it requires caution to begin by assuming what it is, and he insists that facts must be evaluated first. Law then is nothing but a set of social facts. It is a link in the chain of cause and effect. It occupies a place among the facts of the world of time and space. Olivecrona observed that law is nothing but a set of social facts. The rules of law are in no sense the will of the state in the sense of commands, but are independent imperatives issued from time to time by various constitutional agencies. He propounds the view that rules of law are independent imperatives, that is, propositions in imperative form, but not issued like commands from particular persons. Imperative statements found in the law must be distinguished from commands in the accepted sense of that term. According to Olivecrona, a command properly called implies some personal relationship arising where X gives an order directly to Y in the form of words, gestures, intended to affect Y's will and subsequent actions. Even in the absence of a personal relationship between X and Y, the words may have a similar intention and effect as compared with those used when a personal relationship does exist. Thus, an act of parliament is not issued by any individual, nor is addressed specifically to any one person. It is an imperative statement issued independently. It functions as an independent imperative, ordering actions and attracting obedience. According to Olivecrona, the rules of law within a legal system are largely independent imperatives that have passed through a series of recognized formal activities. Citizens assume independent imperatives to be orders which demand obedience, because individuals have been conditioned and trained to think and respond in this manner. The perceived power of the state is surrounded by august ceremonies and met with a traditional and deep-rooted reverence. This has a profound impact upon the individual's mind so that he takes to heart the command of the law as objectively binding. Custom, tradition, feelings of social solidarity and duty, and the residue of generations of historical development combine to assure the binding and non-optional character of independent imperatives. Olivecrona says, morality is founded by the law. From the earliest days of our lives, we are in the grip of the law and our moral views are molded by its influence. Imperatives are inculcated by parents and teachers. They are underlined by our awareness of the consequences, often a stigmatic nature, which attend the failure to act in accordance with an imperative. Hence, our morality is formed by the law and not the other way round. Alf Ross, the Danish jurist, like other Scandinavian realists, insists that laws should be interpreted in the light of social facts by excluding all metaphysical ideas. According to him, jurisprudence is an empirical social science. He says, legal notions must be interpreted as conceptions of social reality, the behavior of man in society, and as nothing else. Like American realists, Ross tends to highlight the position of courts. Law takes the form of a system of normative rules. A norm is a directive which stands in relation of correspondence to social facts. He says, the validity of law does not rest upon any transcendental notions, but merely upon the possibility of one's being able to predict that the rules are likely to be applied appropriately in future disputes. Non-cognitivism in matters of morality and justice was elaborately defended by Ross. According to him, the fundamental postulates concerning the nature of man, which underline the natural law philosophy, are entirely arbitrary. We cannot know objectively what is right or wrong. Such judgments are based on subjective and emotional feelings, and justice can be appealed to for any cause. To invoke justice is the same as banging on the table, an emotional expression which transforms one's demand into an absolute postulate. The only meaning that might possibly be assigned to the concept of justice is that of a reminder addressed to the judge that he should apply the general rules of law correctly and impartially. Ross was strongly influenced by Hägerström's view that statements have meaning only if the propositions they express are capable of proof or verification. This is how he was hostile to metaphysical questions. Unlike his Scandinavian colleagues, he focuses a good deal of his analysis on judicial behavior and its predictability. In this regard, he seems to be working along with his American counterparts. However, Ross differs from American realists by his insistence that decisions which concur with pre-existing rules demonstrate that the rules effectively control the decisions. Harris pointed out the distinction between Ross and Frank. Ross and Frank agree that it is my lawyer's business to predict what courts will do. But Frank says that they are to beware of rules as grounds for prediction, whilst Ross says the rules exist just because they are good grounds for prediction. According to Ross, legal rules govern the entire set of institutions and agencies through which actions ascribed to the state in its legal capacity are undertaken. The primary rules, which may exist as psychological facts only, informing citizens as to how they are expected to behave, become binding. The secondary rules specify sanctions and the conditions under which they will operate. Predictability of the operation of the rules induces confidence in them. To know the secondary rules is to know everything about the existence and content of law. The contribution of Scandinavian realists. The Scandinavian realists opposed metaphysical speculation in jurisprudential thought. They are in favor of the investigation and empirical analysis. Hägerström viewed legal concepts as meaningless unless their interpretation is associated with remedies and other legal procedures. Lundstedt argues law is simply the facts of social existence, all else is illusion. Feelings of justice do not direct the law, on the contrary, they are directed by the law. Olivecrona argues our morality is formed by the law and not the other way around. Ross believes that jurisprudence is an empirical science and acknowledges the normative character of law. As to the impact of Scandinavian realist movement, Friedman writes, its main contribution has been to pursue the detection of open or hidden legal ideologies beyond the usual criticism of natural law doctrines into the positivist concepts of command, sovereignty, rights and duties. By implication, rather than as a matter of articulate philosophy, the Scandinavian realists have demonstrated that any legal order must be conditioned upon a certain scale of values, which can be assessed not in absolute terms, but with regard to the social needs changing with the times, nations and circumstances. Whether law is described as a fact, as a machinery in action or in any other manner, it is directed to certain ends. The view of Julius Stone is that the realist movement is a gloss on the sociological approach. According to C.K. Ellen, the realist school appears as another avatar on the sociological jurisprudence. Criticism against Scandinavian realism. Critics point out that the Scandinavian realists lack a rigorous methodology. Speculation replaces through investigation, and there is a general lack of the disciplined inquiry which characterizes such psychological research. Although the movement has abandoned formal metaphysical interpretations of the law, it seems to have substituted its own neo-metaphysics. Its search for essential characteristic features of the law appears to presuppose a transcendental phenomenon in the same category as the ultimate essence of law associated with some natural law doctrine. Rights and justice are powerful and real concepts which affect the law and its enforcement. To reduce them to the level of non-verifiable concept is to undermine their importance in the administration of law. An excessive concentration on semantics and the inherent problems of the use of words is a hallmark of much Scandinavian speculation. But words are much more than emotive sounds. They have their generally accepted meanings and they are essential to the vast amount of effective communication which takes place within the procedures of the law. The observation that the word justice is meaningless ignores the widely accepted rational significance of the term and the history of powerful movements for social and legal reform mounted in its name. The view that law creates morality seems to be contrary to historical evidence. There is little proof of law creating and conditioning morality. The history of law contained many examples of the moral imperatives resulted in strict legal rules. For example, the widespread abhorrence of murder and the moral imperatives which this reflects have resulted in strict legal rules relating to the consequences of unlawful homicide and not the other way about. The most obvious criticism of Lundstedt is that his concept of social welfare is no less metaphysical than any of the notions he attacks. Friedman says there is little new in Lundstedt's view except the author's claim to originality. The view of Diaz is that there is hardly a school of Scandinavian realism. The individuals who are thought to belong to this group show important differences among themselves. However, they agree in the main in denying the possibility of science of justice or values. It is not possible to construct a science on such a basis. The realist movement in Scandinavia looks to Hägerström as its spiritual father. but its important exponents are Lundstedt, Olivecrona and Ross. In the words of Passmore, no one is wholly self-contained. To understand them or effectively criticize them, one must constantly return to Hägerström. Professor Diaz also points out that if a person searches the book of Olivecrona for guidance in the solution of legal problems, he will fail. There is no hint of values or other such considerations from which law draws its vitality. Although Olivecrona has stated at many places that law is nothing but a set of social facts, he does not explain in his book what he means by fact. Law also provides a model of behavior which presumably is a social fact. American and Scandinavian realism distinguished. Although the association of a particular movement in legal or political thought with national or regional characteristics is not often justified, it has been so in the case of the American realism and Scandinavian realism, whose origin, philosophy and representatives are associated with a particular period and trend in legal thinking. They have developed a characteristic approach to law that has little parallel in other countries. Both are called as realist movements, though they are different in many respects. Lloyd points out, American realists are mainly interested in the practical working of the judicial process, whereas the Scandinavians are more concerned with the theoretical operation of the legal system as a whole. While the American realists are in general pragmatist and behaviorist, emphasizing law in action, the Scandinavian realists launch a philosophical assault on the metaphysical foundations of law. American realists are rule skeptics, whereas Scandinavian realists are metaphysics skeptics. American realists were more empirically minded than the Scandinavians. Lloyd said that the Scandinavian movement, for all its positivism, remains essentially in the European philosophical tradition, whereas the American movement bears many of the characteristics of English empiricism. While the American realists were practicing lawyers, judges and law teachers who sought to approximate legal theory to legal practice, the Scandinavian jurists approached their tasks on a mere abstract plane with the training of philosophers. This lesson is a moderate attempt to explain the distinguishing characteristics of the Scandinavian realist movement and its contribution to legal thinking. Thank you.